Good morning. This is the time set for oral argument on the Worthland and Mahmood defendants' motion for judgment on the pleadings with respect to the claim for alter ego piercing the corporate veil. I have read the papers. I have reviewed the complaint. This is styled as a Rule 12C motion for judgment on the pleadings, but it really reads more like a Rule 12B6 motion to dismiss for failure to state a claim with respect to that one claim. I'll hear oral argument. I'm a little bit concerned about the lack of factual allegations to support the claim. I'll have to tell you that up front. I'm probably inclined to grant leave to amend. I'm not sure what the allegation about trifling capitalization really means. It's an interesting way to put it. I'm gathering from the subsequent allegation that there's it's an attempt to really say that there's insufficient capitalization, but those are my initial thoughts. Mr. Caffer, it's your motion. You may proceed.
Thank you, Your Honor, and I'll try to be brief because it sounds like you're familiar with the facts. I mean, essentially, we have a stock purchase agreement entered into between two entities, really between an entity and the plaintiffs. So PAVE LLC, which is my client, was purchasing the stock owned by plaintiffs Dan and Susan Olson and the company D&O Construction. To be clear, at the time of the purchase, defendants Worthland and Mahmood were the members and managers of PAVE LLC, but are not parties to the contract. These were sophisticated parties. They had attorneys who helped them negotiate the agreement. There are guarantees. Neither Mr. Mahmood or Mr. Worthland were made personal guarantors at the time of entering into the contract. The basic allegations and the basic gravamen of the claim is a breach of contract or an alleged breach of contract, whereby the claim is that PAVE has failed to fully make payments under the stock purchase agreement, and the D&O acts as guarantor under that agreement. That's the substance of it. Now, here's the basic argument and the overview and the lens in which we'd like the court to look at this. You know, when you file a complaint, attorneys are admonished repeatedly that filing a complaint against someone is a big deal. It carries with it certain responsibilities. We see that within Rule 11 that tells us that, I'm sorry, Your Honor?
I was seeing that one of the parties was trying to join, so I was going to stop you, but my assistant allowed him in. So go ahead and proceed.
Yes, Your Honor. So one of the things that we're told as attorneys is that filing a complaint is a big deal. It requires a party who answers as a defendant to incur costs of defense. It requires the party to incur the time of defense. And in addition, particularly with a claim of this type, it requires that party to incur certain reputational costs. And as we pointed out in our motion, this is essentially argued in the complaint, the argument is that allowing for the corporate form somehow works a fraud or injustice upon the Olsons, which means that brand now exists for my clients from now until the end of time. If anyone ever asks them in a deposition or when they apply for a job as a COO or CFO, as they both operate as, whether or not they've ever been involved in litigation, naming them and alleging that they have engaged in some form of fraud or dishonesty, from here on out, they have to say yes. So in order to make that type of claim, there needs to be some pretty sufficient evidence and good allegations. In fact, we cited to the case Trollope v. Kerner. Trollope v. Kerner says that allegations of fraud or injustice should not be used as a make-weight in a breach of contract claim or to otherwise create a panacea of potential options because you don't believe that you have a good remedy under your breach of contract claim. And I think that's really what's happening here. So while we understand that you can engage in notice pleading in Arizona, the case law is pretty clear that notice pleading can't be mere conjecture. There's just too much at stake to allow that to happen. As the court's already identified, members and managers, and this is by statute, are not generally liable for the debts of their company under ARS 293304. Repeatedly, Arizona courts have said that is the law. We do not disregard the corporate form lightly, and that separateness is a fact and should not be disregarded by the courts absent compelling evidence. So the compelling evidence for piercing the corporate veil requires a two-part test. The first is that is that the corporation itself acts as an alter ego of its members, and the second is that there would be some form of fraud or injustice if the corporate form is allowed to proceed or is upheld. And that's from the STF aviation case that we cited to you. So the question is, with regard to the complaint, what's alleged? First of all, there is no allegation necessarily of an alter ego status. The only allegation is as to undercapitalization. The case law says that undercapitalization alone is not sufficient to allege an alter ego status. In fact, plaintiffs agreed with that in their response to our motion to dismiss. And there's case law that we cited to, which was the Norris case, that even full insolvency of a company does not rise to the level to allow you to pierce the corporate veil. Additionally, simply alleging that you're not going to get the benefit of your bargain, and that was in the Farrell case, simply alleging I'm not going to get the benefit of my bargain if I allow this other party to breach the contract, that doesn't rise to the level of our alter ego status. There must be something more, such as a failure to properly follow corporate norms and formalities or commingling of funds. None of that is alleged here. And both parties essentially have told this court that the undercapitalization itself, which is the sole allegation, is not sufficient to support the allegations being made within the complaint. Now, the second prong of the test is injustice, and that injustice or fraud is separate from the alter ego status. Those two issues must be separated, but that's not what the plaintiff does here. Instead, what the plaintiff says is, well, if we don't get paid, that would work an injustice. And that's the allegation within paragraph 35 of their complaint. That, Your Honor, is a breach of contract action. So because it's so important, and because bringing in a defendant, making them defend against a case, and frankly, attacking their reputation as a professional, because it's so important, and because there's mere conjecture in the complaint, we would ask that you dismiss those claims as to Worthlin and Mahmoud.
Okay, thank you. Mr. Smith?
Yes, Your Honor, thank you. Undercapitalization is not, Mr. Kaffer is correct that undercapitalization alone is not enough. However, we do not simply allege undercapitalization. In the employer's liability versus Lunt case, which we cite, the principals knew that they did not have enough money to satisfy the financial obligations that they undertook. And that's what we allege here. PAVE was formed just months before purchasing PAVE. We have no idea what they contributed to it. We have discovery requests pending. I expected we would receive that information in their disclosure statement. They didn't provide it, so I submitted discovery requests asking for information regarding PAVE's capitalization. In every case where you're attempting to pierce the corporate veil, all these factors are within the knowledge of the people within the company. If they're commingling funds among themselves, no one outside is going to know. If they didn't put in any money, no one's going to know that. That's outside. So all these factors are something that has to be pursued during discovery. Every single case that the defendants cite involved, none of them were decided on the pleadings. Every one was decided on summary judgment or after trial or at trial. Not a single one was decided on a motion for summary for judgment on the pleadings. And that's significant because piercing the corporate veil is uniquely factual and intensive. That's what you need, the facts that the defendants have to prove up those claims. We have submitted discovery to attempt to create those claims, to back up those claims. With respect to the court's concern about being a 12B6 or 12C motion, I don't think there really is a distinction. The standard, and we cited in our response that the standard is really the same for both of them. So we've cited cases, 12B6 cases. We didn't make a distinction in filing our response. In this case, the PAVE was formed just a couple months before entering into the contract with my clients. They undertook a $6.5 million obligation to pay my clients. Now, most of that was future payments, note carryback, incentive payments. So the defendants argue in their reply that my clients received millions of dollars in payments and debt relief. That is simply not, there's nothing in the record, and it's simply not true. They received under $2 million at the closing, not the millions of dollars as claimed by the defendants. Really, the defendants have filed a summary judgment brief and called it a Rule 12C motion. They argue that the allegations are thin, the evidence is missing, but those are arguments for another time. Today's question is only whether the defendants Worthlin and Mahmood had a fair notice of the nature and basis of the claim against them. Paragraphs 31 through 36 of the complaint tell them who, what, when, and why. Under the cases of Cullen and Coleman, that's enough. We submit that the motion should be not denied, or if the court feels that it is lacking, that we be allowed to amend, and that we be allowed to amend after we receive our discovery responses that were propounded earlier this month. Thank you.
Okay, thank you. Brief last word.
Your Honor, just a couple of things. First of all, there's a citation made to this Lunt case. The Lunt case is wholly different. So with regard to Lunt, there we had a company that was a going concern, declared insolvency, essentially bankruptcy, 3 weeks prior to taking receipt of produce from an onion company. The onion company gave them roughly $20,000 worth of onions. They sold the onions. Their agricultural business was run out of their personal home. They used the proceeds from those sales 3 weeks after declaring bankruptcy, after signing on behalf of the company, to pay personal bills and then to essentially fund a successor company. Wholly different in kind in this instance. And essentially what the court said is, look, here we definitely have something where this would work in injustice, because you're saying company A, which took receipt of the onions, is not responsible, even though company B and we individually took the value of the sale of those onions. This is not what we're alleging here. In fact, the only argument here is that we failed to make certain payments. And again, I find it interesting that the plaintiff's counsel notes that at the closing, there was nearly $2 million paid at the closing table, and yet claims that there was an undercapitalization of the company. We are now a year since closing that deal, just about, I think in a couple of weeks here. And the company is still a going concern, still registered, hasn't filed for bankruptcy, has hired an attorney and showed up in this court. I don't think that all of that necessarily matters, though, because a Rule 12B or 12C argument does not simply test whether or not there's fair notice of the claim. It tests the sufficiency of the allegations to support the claim. And in this instance, the only allegations made are, number one, undercapitalization, which plaintiffs admit is not sufficient to support a claim for piercing the corporate veil. And number two, that the undercapital, or that the alter ego status somehow works in injustice. And again, there's no allegation as to that other than we might not get paid. But since all the case law says we might not get paid as a breach of contract action, and since the statute itself, that's 293304, specifically says members and managers are not liable for the debts of the company, none of that matters. There's simply an insufficient claim. That's the argument that's being made. It's not about the notice of the argument. It's the argument on its face is mere conjecture. And to just underscore that point, there shouldn't be claims filed and then plaintiff's counsel starts looking for evidence to support the claim. Plaintiff's counsel is supposed to, under Rule 11, make a reasonable investigation and on the basis of that investigation, file the claim. If during discovery it became known that there was some form of fraud, fine, add Mahmoud and Worthland if that's the case. But that's not the case here, and discovery wouldn't show that. To start with damaging their reputation first, and then see if you can back it up later, is just an untenable way to file a complaint, Your Honor. So on that basis, we would ask that the claims be dismissed.
Okay, I'll go ahead and issue a ruling on the motion here in open court. Here's the issue. A claim for piercing the corporate veil or alter ego is inherently factual, and typically I would say file a motion for summary judgment and address it that way. If the evidence is, if there's no genuine issue of material fact and the evidence is just insufficient, that's usually the way I treat these types of issues, and I allow development of the factual record and allow the claim to go forward. I have to, obviously, when addressing this, either as a Rule 12C motion or if it were filed under Rule 12B6, I have to assume the truth of all well-pled factual allegations, but I don't have to assume the truth of conclusory allegations. And in looking at the well-pled factual allegations, I think they're insufficient here at this point to go forward with count 4 on piercing the corporate veil or alter ego. For the reasons I set out on the record at the outset, there was reference to some factual issues here in the argument by Mr. Smith about when PACE or PAVE was formed. I went through the complaint. I didn't see any of that in the complaint. When I heard that, I was scrolling through the complaint here to see if there was any allegation about that. And I'm not saying that alone would be enough to state a claim, but what I do conclude at this point is the well-pled factual allegations in the complaint at this point are insufficient to state a claim for piercing the corporate veil or alter ego. So I'm going to dismiss count 4. I'll grant the motion and dismiss count 4, but I am going to grant leave to amend. And ordinarily, when I grant a motion to dismiss, or in this case, a motion for judgment on the pleadings, I would set a date for filing the amended complaint. I'm not going to do that here because, as Mr. Smith indicates, he's waiting on discovery that he thinks is going to make him able to make more specific factual allegations, and I'm going to give him that opportunity to do that. So I'm not going to set a deadline for amending the complaint, but if you think that you've developed a good faith basis under Rule 11, Mr. Smith, down the road to seek leave to amend, you can file a motion for leave to amend, and then I'll take a look at that and decide whether to grant leave at that point. But I am going to give you an opportunity down the road once you think you've developed a basis to make those allegations, if ever. Okay, so the motion is granted with the understanding that Mr. Smith likely will be seeking leave down the road, and just so that everybody's clear on leave to amend, I take Rule 15 at its word that leave to amend is to be liberally granted. So just keep that in mind, Mr. Capper, when you're looking at whether the proposed amended complaint down the road is sufficient. Okay?
Understood, Your Honor.
Thank you.
Okay, thank you, everybody. Have a good day.
Thank you, Your Honor.